They won't give residency to anybody. There's a stamp of the UAE government.
But that is real or forged, we don't know. I am sitting in the court at Ahmedabad, I would not know with the genuineness of the document. It would be the ED, they would be verifying it. Now they are unreachable. Provide it.
Please provide.
Let it go beyond Diwali now.
Your Worship, I request for a
No, we are indoors. Allergy, okay, wait. Look on order. PDS file is a reply stating that they are not in a position to wait.
ગામના સ્ટુડન્ટ સાથે પ્રેમ સંબંધના કારણે બે વખત ભાગી ગયેલ હોવાથી ગામના આગેવાન તરીકે ગામ અને સમાજમાં બદનામી થવાથી સ્ટુડન્ટનો પરિવાર ગામ છોડી નરોડા અમદાવાદ ખાતે રહેવા જતા રહેલા હોવા છતાં સ્ટુડન્ટ સાથે લગ્ન કરાવવાની જીદ કરતી હોય અને તેની સાથે ફરતી ભાગી જવાનું કહેતી હોય તેથી સ્ટુડન્ટના પરિવારના માણસોએ ગામમાં અને સમાજમાં આબરૂ જવાની બીકે અને પોતાની વધુ બદનામી ન થાય તેમજ સ્ટુડન્ટો એક જ સમાજનો હોય તે બંનેના સામાજિક રીત રિવાજ મુજબ લગ્ન થઈ શકે તેમ ન હોય જે વાત સ્ટુડન્ટોએ તેના પરિવાર દ્વારા સમજાવવા છતાં સમજાતી ન હોય જેથી ઉપરોક્ત તમામ આરોપીઓ ભેગા હોય પૂર્વ આયોજિત કાવતરોથી આરોપી નંબર 1 સ્ટુડન્ટોના પિતા અરવિંદ સોલંકી, નંબર 2 પિપરાઈભાઈ ગજેન્દ્રસિંહ સોલંકી ના હોય સ્ટુડન્ટોને પોતાની અણઘડ થઈ વડોદરા હાલોર હાઈવે ઉપર નર્મદા કેનાલ લઈ જઈ ગળે ટૂંપો દે મોત નિપજાવી તેમજ સ્ટુડન્ટોની લાશને બાકરોલ ખાતે લાવી તમામ આરોપીઓ ભેગા મળી સ્ટુડન્ટોને લાશને રાતના અંધારામાં ચોરી ચૂકીથી લાકડાની ચિતા ઉપર સળગાવી દે છે હાલના જે અરજદાર છે એ એક્યુઝ નંબર 3 અને 4 છે.
I have rejected of number 5.
પાછો વખત છે
But I have rejected. I think Popotsang son.
અચ્છા એ પ્રિન્સિપલ એક્યુઝ છે પોપટના સનની અસર ગજેન્દ્રસિંહ છે જે નંબર 1 કે 3 છે સર એ આ મરણ દેનાર દીકરીને સાહેબ હાલોર હાઈવે ઉપર લઈ ગયા સાહેબ નર્મદા કેનાલ ઉપર.
Yes, your son Raddeep Singh.
હા જી સર એટલે હાલના આરોપમાં સાહેબ રોલ જે છે એ સાહેબ એટ ધ ટાઈમ ઓફ
But
ઇન્સિડન્ટ
for
સાહેબ
number 5 I have rejected. I think day before yesterday or I rejected.
પ્રિન્સિપલ એક્યુઝ છે મારો પુરાવાનો નાશ કરવાનો સાહેબ આક્ષેપ આવે કોલમ પેજ નંબર 12 ઉપર સાહેબ લાસ્ટ પેરેગ્રાફ પાસે
It's a honor
જેમાં
killing.
મારી કોલ ડિટેલ લોકેશન સાહેબ બનાવવાની જગ્યા ઉપર મારી હાજરી બતાવવામાં આવે છે વધુમાં વધુ સર ઇન્ટેન્શન તો મોટી શોટ ક્યાંય નહીં there is not past anti incident સર કોઈ ગુનાહિત ઇતિહાસ નહીં સર
But honor killing.
નંબર 1 અને 2 3 પૂછું છે સર કે જે વ્યક્તિ ખરેખરમાં આ વસ્તુ બની છે ત્યારે બનાવના સ્થળે હાજર છે સાહેબ આઈઓનો એફિડેવિટમાં પણ સાહેબ એ છે આ જે આરોપી છે સાહેબ એમના પૂરતો રોલ સાહેબ પુરાવાનો નાશ કરવાનો સાહેબ આવે છે એ એઝ પર ધ એફઆઈઆર સર પેજ નંબર 12 ઉપર સાહેબ લાસ્ટ પેરેગ્રાફ વાંચવામાં આવે તો એમની કોલ ડિટેલ લોકેશન સાહેબ એ બધી જ વસ્તુ સાહેબ જે તે જગ્યાની સાહેબ મળી આવે જે બનાવ બન્યો જ્યાં દીકરીને મારી નાખવામાં આવી છે ત્યાં પેલા 3 જ આરોપી સાહેબ હાજર આ બે અરજદારો સાહેબ એ જગ્યા ઉપર ક્યાંય ગયા નથી
Yes.
મસાલમાં સાહેબ જે અંતિમ વિધિ થઈ છે એ જે પુરાવાનો નાશ થયો છે ત્યાં આગળ સાહેબ મારી હાજરી છે.
This is the honor killing. You were all were relatives.
સર ફોન આવશે તો રિલેટિવ નો પોત ઉપડવામાં આવશે કારણ કે બધા રિલેટિવ ભાઈ છે એટલે ફોન ડિટેલ ઉપરથી સાહેબ આ વસ્તુ થઈ છે ઓબ્વિયસ
सरकारी ऑफिस से पीएम के लिए
ચોસઠના નિવેદનમાં એમનું નામ ખોલેલું છે.
બીજું કેવું છે
ના બસ
આરોપી રિજેક્ટ કરી છે
આજે
complaint. 128.
Right hand side top of the paintings.
128.
12. 12 to 128 total. First. Starts at page 12.
Yes.
Now kindly see. The page 12, the complaint is being PMLA case number 14 of 2024. And you see the title, my lord, this is a supplementary prosecution complaint. That is in continuation to the earlier complaint of 9 of 2023. 9 of 2023, which is at page 242, my lord.
Page 42.
242, these are the main complaint.
Yes.
Can we see page 242 first? The complaint was started in the year on 24th July 2023. Because in the ECIR, they have relied upon 2 schedule offences. For one of the schedule offence, they already filed as a complaint on 24th July 2023, that is on page 242. Now that complaint was filed against the 6 accused that I was not named. And none of these 6 accused have been arrested.
Yes.
Allegations against these 6 accused as forming part of the scheduled offence that this accused, particularly is accused number 2, along with the other 2 accused, has created the connect point in the Sudan and collected the crores of rupees from the general public by saying that we are launching a new coin, like the Bitcoin, Ether coin, which is known in the world. So this is an Indian coin. They floated a coin, and the price went up to $463. So collected crores of rupees. I am one of the investors of that coin. Based on the representations made by this accused number 2, Dhaval Mamani and others, I invested money in that coin. That coin name is a Bitcoin. BitConnect coin. BitConnect is short name of this coin. Is BitConnect. Now, in this respect, after filing this complaint, the complaint impugned here in the present case is at page 12. Therefore, they say the supplementary complaint. Page 12 automatically is the title. The supplementary prosecution complaint, main prosecution complaint, PMLA 9 of 2023, filed under section so and so, and so and so. So this complaint is only pertaining to the present applicant only. There are no other accused. Now, this complaint is not complete, it is still pending. That my lord, can you see the first? The pending investigation, this complaint has been filed. My first contention is that this is an incomplete complaint so far as the present applicant charge sheet is not, investigation is not completed, and therefore I am entitled to a default pay. Now the title also has just made this a say that I am making application in the 167(2). Now there's a present. Just there's a new act, it is 483. Sorry, 187. New section is 187, subsection 2 of DNSS.
This
So
complaint is,
proximity
you are now, this is default bail.
default as well as on the merit both. I'm praying both on the both the grounds. If I use the provisions of DNSS, then 187(2) and 483, read with section 45 of PMLA. I made very clear in my title itself, my lot of this bill application. Can you see the first page? Even in the first paragraph also I have made clear. So title I have made very clear and I have made respective governments also. Why I am claiming the default bail under this provision. I'll take the honorable court to that, for the then I'll go on merit.
There is no prayer for default. In the prayer, there is no. Either you may submit on merits or on default.
So I am on.
Both are different.
Yes, they are different, but
There is no prayer for default bill. There is no prayer.
I have made governments, I'll read this, those governments.
But then your prayer is not for default bail.
It can be this, if they are so technical, I'll amend the prayer. Otherwise, I have made this prayer and I have made this a contention to that specific effect. I am entitled for default bail. Then I may be granted leave to amend, I'll amend the prayer, if my friend is so technical.
No, it is not about technical.
But otherwise, if you
No.
the honorable court to grant default bail, that's the judgment of the Supreme Court.
No, I am only on the aspect that if he is claiming default bail, then there is no point of arguing on merits.
I'm not.
Both are different, my lord.
Permit me to amend.
No, that is not the point. What I am submitting is different.
Sure, it's not specifically worded. That's why I'm saying I may be permitted to amend the prayer on those aspects. Otherwise, I make very clear in the title itself that I'm praying on.
No, then there is no question of hearing on merits.
No, there is no restrictions.
No, both
I can
cannot be,
argue
my
on
lord.
both the lines.
My lord, both cannot be.
If you are asking for default bail, then the consideration would be only confined for the
No,
default
it's
bail.
not.
Exactly, my lord.
Judgment, so the both has been heard together, their orders have been passed and Supreme Court has not interfered. The judgments are there on those lines also, my lord. And I have quoted in my bail application also those judgments.
Those judgments.
So now I'll take this as fact and then I'll go to the law point and judgment. Now can you see page 109? Bottom, paragraph 13, bottom last line.
Yes.
Now they say further investigation pending in the case, further investigation. Now, further investigation in respect of what? That is important. With respect to other accused or the applicant, that is to be seen. If it is other accused, I have no right. If with respect to me, then only I can claim. Now kindly see, further investigation pending in the case, further investigation in respect of the remaining process of crime is in progress. The complaint reserves his right to file supplementary complaint if required at a later stage. So those are in these complaints. The process of crime as per their allegations is entirely with me for their proximity, the contention on page 104. Paragraph 104.
Yes.
And can you see paragraph 12, my lord? The specific role of Saleh Rahul Alpha, my lord. So I'm not referring entire complaint, they have summarized my role here. This is the repetition of the schedule offensive. To avoid the repetition, I'm straightway coming to the my role. Now, kindly see, Saleh Rahul but he is the main accused in FIR number 3 of 2028 on 19/2019 registered. So this was in 2018, this FIR was registered. They allege I was the main accused. Now, fact remains this have been granted anticipated bail by the Supreme Court in this offence. Until date, there is no charge sheet has been filed. for me in that offense, my lord. And the order of the Supreme Court granting me anticipatory bail is on page 239, my lord. Can you see that? Then I'll read further here. So it remains in continuation.
Yes, you have reported this earlier.
Yes.
Yes.
So just to complete to page 239 is honorable court. So the paging would be different than earlier application. That's why
No.
to make this a complete note and reference, my lord. My learned pen was not there, so I should not see other. There is change on the other side, that's why.
But that is for them to decide.
But he may not be even what I argued earlier.
He has to go through all these bunches of paper and he will go there.
Yes, I am aware. Okay, this I'm not reading it, just drawing your attention on number 4. On 239, the Honorable Supreme Court on December 2019, while issuing a notice, protected me by no coercive action, and the order was made final on 15th February 2023 at page 240. So I am on an anticipatory bail until the charge sheet is not filed for me in the schedule offense. I am only accusing this out of 2 schedule offenses referred in ECIR, one only. So therefore, I was reading page 104, third line, my lord. All these offenses, blah 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 blah, and so on and so. In connection with hatching a conspiracy of kidnapping Piyush Savalia and Dhaval Mamani, for them the first complaint has been filed. Offending them, beating them, threatening them, using false identity of those of public servants, showing firearms. Now, neither Piyush Savalia nor Dhaval Mamani had registered any FIR. It was by the police. Since I initiated proceedings against the police, I have been arrested here. As per the charge sheet filed in the said FIR, Salias Babulal Bhatt and his accomplice by a committee. So charge sheet is not filed against me, my lord. Charge sheet is being filed against the co-accused only. This statement is incorrect here. The charge sheet is not filed for me. Page 105, second line is incorrect statement. Third line, what they say as per the charge sheet is not filed for me.
Yes.
Third line. Can you read?
Yes.
As per the charge sheet is not filed for me. It is for the co-accused only.
Yes.
Salias Babulal Bhatt and his accomplice by way of committing the schedule offense under section so and so extorted 2091 bitcoins, 11,000 Litecoins equivalent to 166 bitcoin, and 14.5 crores cash. Salias Babulal Bhatt and his accomplice also threatened and forced the victim, Ms. Piyush Savalia, to leave the country so that no police complaint could be lodged into the said matter, and due to that apprehension of being caught, Salias Babulal Bhatt, Ignesh Moradia, Ignesh Nemi, allegedly put extreme pressure on Piyush Savalia and made him to sign an affidavit to the effect that he did not know Salias Babulal Bhatt and his accomplice. Thus, Salias Bhatt has allegedly committed the schedule offense as detailed above. Now, this is the accordingly. As per the charge sheet filed in the FIR number 3 of the petition, so Salias Babulal Bhatt by allegedly committing. So again, is the incorrect statement that the charge sheet is not filed against me. Committing the schedule offense has derived as the following. So these are the allegations of the FIR. Now these are the proceeds of crime what has been mentioned here. Now can we see on 1/2/2018, 2091 bitcoins in the Bitcoin. Bitcoins in the Bitcoin wallet address bearing number so and so, then second on 1/8/1/2018, 11,000 Litecoins in like one wallet at a so and so, and third 14.5 crores cash in accounts of Umesh and Sons Angaria. Now, this is the only process of crime as per their contention, pilot complaint file. Now, this process of crime, they say is yet to be recovered. They do not say this process of crime is to be recovered from any other person. That paragraph 109, which I have read is the last paragraph, my lord. Kindly see in page 110. They say remaining process of crime is in progress. Investigation, I just exactly read the line. Further investigation in respect of the remaining process of crime is in progress. So it is not to be investigated any other accused. If any other accused is to be investigated, then it would say me complaint is complete. The charge sheet is complete. But investigation me only if it is continued, then it is incomplete charge. There is a distinction between two. Further investigation other accused and further investigation me. The further investigation me, then charge sheet is incomplete. So that is what my submission is, my first contention. Now kindly see the sections, my lord. 187. Because in PMLA is a silent, we'll have to borrow. By reading section 65, reading with 71, the CRPC will come in picture.
Okay.
187. Now, CRPC. The orderly set. That was June order. Now the can see 167.
185.
187, which is corresponding section of 166. One 187.
Yes.
Very fun. Procedure when investigations cannot be completed in 24 hours. Can the title itself suggests that investigation is to be completed. The kindly mark the word completed. Investigation and completed. There are two key words. If this investigation is not completed, then only this section will come into the picture. If the investigation is completed within 24 hours, then this section will not come into the picture. So the key word is investigation and completed. Wherever any person is arrested and denied in custody, and it appears that the investigation cannot be completed, kindly word because I am harping on this word completion of the investigation. Section does not say filing of the challan pending investigation. The challan filed pending investigation is not compliance of this section. The section uses the word completed. So therefore, it appears that the investigation cannot be completed within this period of 24 hours fixed by section 58, and there are grounds for believing that the accusation or information is well founded. The officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in diary written after specified relating to the case, and shall at the same time forward the accused to such magistrate. Then subsection 2. The magistrate to whom an accused is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as the magistrate thinks fit, for a term not exceeding 15 days in whole or in parts at any time during the initial 40 days or 60 days out of the detention of 60 days or 90 days as the case may be, as provided in subsection 3 and if he has no jurisdiction to try the case or commit it for trial, the considerations further considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. 3. The magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate ground exists for doing so, but no magistrate shall authorize the detention of the accused person in custody under these subsections for the total period exceeding 90 days, whereas the investigation relates to an offence punishable with death or imprisonment for a term, imprisonment for life or imprisonment for a term 10 years or more, 60 days where the investigation relates to any other offence on an expiry of the said period of 90 days or 60 days. As the case may be, this accused person shall be released on bail if he is prepared to and thus furnish bail, and every person released on bail under this subsection shall be deemed to be so released under provision of 2022. Now, therefore, there is some change in earlier section and there's a present section with respect to it only. Earlier, there's a view of there's a remand can be granted only on the first 15 days. Now there is a change that 15 days remain the same, but it could be any time in 60 days or the 90 days. Earlier it was mentioned after the arrest, immediately the 15 days remand was there. Now that's only changed, otherwise section remains the same. So therefore, what is being required under this section is completion of investigation. The completion of investigation is not complete, the investigation is not completed, and it charge sheet here it would have a private complaint is filed, then that will it would amount to circumventing statutory and fundamental right. Because the fundamental right of default bail cannot be circumvented by filing a charge sheet pending investigation. Now they say in the complaint there is only one accused, they say, and is the only one accused and is a complaint is been made. Now kindly see the ECIR, they have this page 1 by 1.
Page.
Page 1, annexure 1A, page 1.
Yes.
Now kindly see ECIR column number 3, my lord. In the column 1, they have given us ECIR is of 2019. It was released on 30th September 2019. And I got it first column, first
Yes.
row. Then row number 3. They are relying on 2 FIRs. FI number 03 of 2018, dated 19/5/2018. Then second is 6 of 2018, dated 21/7/2018. So far as the second 6 of 2019, they have filed as the ECIR 9 of 2023, where no accused has been arrested. So far as FI number 3 of 2018. The PMLA complaint 9 of 23 on page 242.
For 6 of 2018.
Yes, that is the PMLA 9 of 2023, which is at page 242 of this compilation, is filed against the accused of FI number 6 of 2018.
Yes.
Whereas this the present complaint is being filed against the accused of 3 of 2018. Now this again this complaint is filed against the accused who is not charge sheeted. Whereas in 3 of 2018 there are certain accused who have been charge sheeted on and on bail, against which till that there is no PMLA complaint.
Yes.
Now, if I say in other words, in that there are 2 schedule offences. Out of the two scheduled offences, many have been arrested on regular bail, released on bail. Charge sheet has been filed, criminal cases have been registered. But in PMLA, I am the only one who has been arrested because I lodged an FIR against the police officials to extort these very same proceeds of crime. My allegation against those officers that these officers have extorted money from me, which as per their allegation I extorted from the double mawan in Piyush Savalia. So let's assume I took 100 rupees from double mawani. Out of which 15 rupees is taken by the Junagadh police officials. So that out of this 100 rupees is proceeds of crime, 15 rupees admittedly taken by those officials. And 10 rupees is taken by the CBI officer. They are also the specific. So that 25 rupees it is on record by because they CBI officials and police officials are being charge sheeted. Charge sheeted, the ED is silent for investigating on those aspects. They are not arrested even. And when they have been charge sheeted because the proceeds of crime is 100 rupees. On investigated, it is put that 25 rupees is gone to the CBI officials and police officials. It is their investigation says. But these ED officials are filtering those officers. No action against them. No arrest against the double mawani and company.
Yes.
So there is no fair play at the hands of the investigation officer. The investigation officer has to be just and fair.
And more responsible.
For the purpose of the investigation. There cannot be this pick and choose policy. If I have committed an offense of this and earned proceeds of crime, then offense only completes when it is being laundered. If that 25 rupees has been laundered in hands of those police officers or the CBI officials, why not take an action against them? There is no reason, no justification. Company is absolutely silent. Now they say, I have committed. Now my case is that it was my investment. They all of a sudden closed the company. I said, you give me my money, my investment along with my profit. It is because at a given day, the rate of the big connect point was $463. You give me my money back. Now they are labeling my recovery as extortion. I say I recovered my money back. They say I extorted. But they do not say anything about what the police officer did with me. They collected money for what? From me. The entire investigation is in cloud. And that cloud has not been cleared or corrected while filing a payment account.
Yes.
Now, can you see page 49 of my bail application, where I made specific government with respect to default bail. Page 49, para 14.
For default bail.
For default bail is a specific government starts at para 87 on page 55 onwards. So 439 also discussed, and then page 87 onwards, 167(2). You've got it. I'm not reading all those entire discussions on various case laws will be at great length has been discussed by the Delhi High Court.
So what I'm getting from your submission is that
I'll still come to conclusion now, page 74. Para 130. Investigation has to be completed.
yes,
Honorable Court,
Yes.
page, para 113, page 74.
yes,
The legal position pertaining to the scope of section 167(2) of the court emanating from the above preferred decisions can be summarized as under. The object of section 167(2) of the code is to ensure an expeditious investigation and fair trial, and is another aim of Article 21. The accused has inevitable right in his favor for being released on bail on account of default by the agency to complete, again as word is being given, complete is being highlighted. Agency to complete investigation within the stipulated period time. So without completing this investigation, one files a complaint and then say for number of years the investigation is pending, so that's not permissible. Then 3, it is a duty of the court to ensure that benefit of section 137(2) of the court be given to the accused, and detention beyond statutory period would be illegal, being opposed to the liberty of the accused. Section 173 of the court does not stipulate, this is what I am arguing, so specifically answer. Section 173 of the court does not stipulate that the piecemeal investigation and filing of incomplete charge sheet before the court and contemplates filing of the final report after completion of the entire investigation of the case in respect of all offences, and where several offences are involved in a case, the practice of filing preliminary charge sheet to seek extension of remand beyond the statutory period should be deprecated. That is exactly I am arguing before this honorable court. To circumvent my default bail, they came at 58 days, filed a complaint to see that I don't get default bail, and made our mind that investigation is pending, therefore accused should not be released on bail. Otherwise, my investigation will be jeopardized. And 4, the charge report can be filed before the court only after, only after investigation is over. The word is used only after investigation is over. And formation of an opinion regarding all offences alleged against the accused. Then 6, there is a distinction between completion of investigation and further investigation. The further investigation can be resorted to only after the completion of investigation and filing of charge sheet. So by filing half-hearted committee can also further investigation. Once the investigation is completed, then only it can be a further investigation. Otherwise, it is a continuation of the investigation. What is being present, the status, is a continuation of the investigation, not the further investigation. Then 7. The investigating agency cannot circumvent section 167(2) of the code by filing incomplete charge sheet. The police report or the charge sheet cannot be sent within the meaning of section 173 till the investigation is completed, and any report sent before the investigation is completed will not be a police report within the meaning of section 173 of the code. So this will not be considered as compliance of 173. The High Court made very clear. The incomplete charge sheet filed without completing the investigation cannot be used to defeat the right of statutory bail under section 167(2) of the code. The right of the accused to statutory bail came to be and the charge sheet is filed within the stipulated period. The filing of charge sheet is sufficient compliance with the provision of section 167(2) of the code and taking cognizance is not material to section 167. There can only be one charge sheet, but there is no restriction on filing number of supplementary charge sheet. The charge sheet can be said to be complete when it is enabled with the court to take or not to take cognizance of the offense after application of mind, and if certain precedents called for further investigation does not render such report anything other than a final report. The power of magistrate to take cognizance is not lost even if the police report is termed as incomplete by the investigation officer. If the charge sheet is not filed, then right of default date has leaked into the status of inadmissibility, which cannot be frustrated by the prosecution and the courts on any aspect. That is the last is not this economic offense on this. On this basis, the Honorable Court granted default bill. Now, this was challenged before the Honorable Supreme Court. Para 115 is further elaboration on this aspect. Now, this judgment was taken to the Honorable Supreme Court.
Yes.
Now, kindly see. The present petitions have been filed assailing the order reviewed passed by the High Court with a 28/9/2022 granting default bail. Now, kindly mark the grant, though it was regular bail as well as the default bail of CRPC. After we have heard learned additional solicitor general appearing for the petitioner, we find no reason to interfere with the order reviewed. However, we make it clear that the observations which have been made by this High Court is only limited for examining the scope and ambit of the report bill 167(2) code and will not affect the merit of the trial.
Last line is most important.
Yes, these special petitions are dismissed with this above observation.
No, last.
The questions of law, if any, is left open. But these questions of law decided by this Delhi High Court has not been interfered.
But then what is this question of law?
Pardon?
How, what is to be understood by this question of law? This line
The last line says
Ah.
that the question of law, if any, is left open. So the Honorable Supreme Court has not held anything on law or decided any. No. No.
I said not interfered, I only said that.
That was the only thing.
But then what question of law?
No. On 167, my learned friend is arguing something.
He is arguing on 167.
Correct.
The High Court granted on 167. That
So
order
the
has been
Honorable
confirmed.
Supreme Court has not decided any law point in this particular judgment. That is what my submission is.
But that order has been confirmed.
Yes. On a particular fact. That is
Particular
yes,
fact.
Yes.
Yes.
That is the only thing.
Now kindly see there's the next judgment page 79. In fact, this 79 was the judgment prior to the Delhi High Court. This page 79 judgment of the Madras High Court was considered by the Delhi High Court. I can show the reference of this judgment. In the Delhi High Court.
Yes.
I'm trying to find out where the mother side was then recorded. What about the paragraph? Yes. Actually, page 65, running page 65. Whereas the Madras High Court has been recorded. Para 102. Page 65, bottom, para 102. Telangana High Court. In the High Court in C. Parsati versus Director of Enforcement in so and so. From the above decision, it is clear that the time limit for completing investigation was incorporated in order to ensure that the accused does not languish in jail for a period for the investigation of authorities failure to complete investigation. It was held that as a right to statutory bail accrues on a person if the charge sheet is not filed within the prescribed period of 60 days. The said right to bail is indivisible and is interlinked with personal liberty as envisaged under Article 20 of the Constitution of India. The Supreme Court in Satya so and so versus so and so reported in so and so held that the charge sheet can be filed only after the completion of investigation. The relevant paragraph is accepted below. Section 173(2)(1) provides that on completion of the investigation, the police officer investigating into a cognizable offence shall submit a report in the form prescribed by the state government and stating therein the names of the parties, the nature of the information, the names of the persons who appear to be acquainted with the circumstances of the case, whether any offence appears to have been committed, and if so, by whom, whether the accused has been arrested, whether he has been released on his bond, and if so, whether with or without sureties, whether he has been forwarded in the custody under section so and so, makes it obligatory upon the police officer to forward along with the report all documents or relevant extract thereof on which the prosecution proposes to rely, and is the statement recorded under section 161 of all persons whom the prosecution proposes to examine as witness in the trial. Similarly, the Supreme Court in Manu Sharma has held that the object behind section 173 of the CRPC is to complete the investigation and file the charge sheet. The idea is to ensure that cognizance is taken without any delay. The relevant paragraph is expected below. Section 173 commands the investigation agency to complete the investigation. So, and we have what on completion of investigation is the way it has been given expeditiously. And then this para, what is being longly quoted, sitting the para 15 of that C Parsati. Approximately just the next judgment, Telangana High Court. Where my lord will find para 15 is the same. What is being first quoted. On the point of me, it is important on can you see running page 80, where is the contention of both is being quoted. What my friend is arguing is exactly there. On page 80, now can you see contentions of the petitioner? What was the argued before the court and court has what held? The complaint in the nature of interim report was filed on 19/3/22. No complaint charge sheet in terms of section 172 of CRPC is filed as the investigation admittedly is not completed. Therefore, in the absence of completion of investigation, the petitioner is entitled for statutory bail under section 157(2) of CRPC after a period of 50 days, which accrued on 21/3/2022. The complaint dated 19/3/22 was filed only to deny statutory bail to the petitioner. The object of section 167(2) of CRPC is to complete the investigation within the prescribed time. Failure of the prosecution to complete the investigation and file charge sheet within prescribed time will give to the accused the right objective to the bail. Reliance was placed on M. Ravindran. It designated court has no power to return the bail application filed under section 160 of CRPC. Reliance was placed on Director of Enforcement versus Kama Srinivas Rao. The petitioner was not produced before the designated court when the remand was acted. Then contention of the respondent. The complaint charge sheet was already filed on 19/3/2022. Therefore, statutory bail under section 157(2) of CRPC cannot be claimed once the charge sheet is filed. The reliance was placed on so-and-so versus Rahul Modi. Remand was extended under section 309 of CRPC and respondent can seek custody of the petitioner to complete further investigation in section 44(2) of PMLA. The petitioner is trying to claim statutory bail to overcome the requirement of bail under section 45 of the PMLA. The petitioner did not oppose remand which was extended under section 309 of CRPC. Now, after considering this was the main contention raised, and the court granted bail. Possible fine para 15. What has been recorded by Delhi High Court? There it is been quoted as para 16, but in fact it is a para 15. On page 83. I'm not reading it again, I'm just showing. And then para 21 is rightly quoted, the same. And ultimately, this is the Honorable Telangana High Court had considered at great detail in granted bail on para 29, not see that. Last. (29) and 30. Even they referred Jagannath, the court said we do not agree. Because Ashok Munilal, what had happened in Madras High Court? In Madras High Court in Ashok Munilal did not grant 167 to default by saying there is no provision in PMLA. Matter went up to the Supreme Court in Ashok Munilal said, since there is no specific provision in PMLA, 167 will apply to PMLA. That has been quoted in para 29. Ashok Munilal Jain Manor. And the bill was granted on para 30. Manor will find. The bill was granted on the 167. Now, this judgment of Telangana High Court was also challenged to the Supreme Court. Though notice is issued, the order is not stayed. SLP is still pending. On 10th October 2022, against the judgment of Telangana High Court, the Honorable Supreme Court issued notice, retirable in 2 weeks. That's all. The order or observation is not been stayed. So, in the two judgments of the Telangana High Court and Delhi High Court, where specifically this issue was raised about the pendency of the investigation. In one, Supreme Court has already not interfered, another SLP is pending of the ED.
Yes.
Now, on the evidence deployed, they have relied upon. I must draw the attention. Option fine. In affidavit deployed. In page 38, Roman page 38. Para 4.21 sub. Para 4.20. para 4.21, page 28. Yes, I stand corrected by one. Para 4.21, and Roman stance.
Yes.
In that they have referred one judgment. Last 5 months. However, the investigation in respect of the accused and any other person whosoever is in progress, it becomes pertinent to state that the decision of the Honorable Supreme Court at this juncture regarding the pendency of the investigation in the recent judgment of so and so, in which they stated they are relying on these. Now, these judgment with respect to a different accused. Check copy number that is liar. તમે rely કરો છો આનું કપિલ વાસવાનું આપણે take it before. Sorry, this I got only one copy. This is just paragraph or just paragraph. Compare કરો.
ભાઈ આ છે કોપી તમારી લાઈવ લો વાળી એટલે અલગ હશે
ના મેં કીધું ડાયરેક્ટ કાઢ્યું છે એટલે પહેલા એ ગુસ્સી મુદ્દા શું આવ્યો.
but even otherwise I will be referring to this.
That's why I'm just answering to what they have said in the affidavit reply. I'm just distinguishing this judgment on the aspect that here also this 167(2) bail was granted after filing a charge sheet. So the distinguishing feature is that in that Supreme Court held that the investigation was pending for other issues. That's all I just draw the attention. Here, in the present offense and the judgment to which I cited, in which investigations were pending for the accused, same accused only. That's the distinguishing feature here. So this judgment will not apply of the facts of the present case. And the judgment which I have relied upon, in one, the Supreme Court not interfered, in another stage not granted. In this judgment, which my friend is relying, where the investigation was pending for other accused. And it was made very clear that investigation for the accused was completed. Here, therefore, this judgment will not apply into the facts of the present. So this was in 167(2), my lord. Now I come back to the merits.
Yes.
I can see the PCI here. So this is my alternative submission to the Honorable Court does not find clear of my submissions of granting default payment. Then it be considered on merit.
Yes.
Can you see page 1 PCI agreement? Where there are the two FIR, the two scheduled offenses have been recorded. Page 1. Where the FIR 03 up to 18, I'm accused in that one only, not in that. Where my name has been recorded accused number 10, A10. Now, out of they are referred in all 17 accused. The now 2 complaints has been filed. In the present complaint, where I am the only accused, and in PMLA 9, there are 6 accused. Out of 17, they have filed complaint against 7 accused in all to, if I say otherwise. And out of them, only the present applicant has been arrested, whereas the allegations against the other schedule offense, the 06, whereas the allegations are much more senior in terms of the allegation, in terms of the cheating of the public at large, in terms of the amount involved in it. and is not comparable, both of them. And that fact has come on record by way of the remand application and in the complaints. The investigation officer selectively arrests one person only, that is the present applicant, because he refused to get hostile before the CBI. Because the CBI officer against whom I registered a complaint, which has been converted into the FIR, where they have taken 4.5 crores from me, which was also part of this alleged process of crime. However, no action against that CBI officer. If they say whatever money I recovered from the Dawal Mawani is a process of crime, and out of that money only I have given 4.5 crores to CBI officer and his continuous. If money which I recovered from Dawal Mawani and party is process of crime, then it has been further laundered to CBI officer, no arrest, no action against them. If the money which I recovered from Dawal Mawani and party has been given to the IPS officer of the Junagadh and other police parties, probably Jagdish Patel, if I don't make a mistake by naming, no action against any of those officials. They say investigation is pending. Now, since 2019, they are in investigation. 5 years is completed.
Yes.
I have appeared many times before them. Approximately para 7, now page 7, para 5.13, I have made specific comments in my bail application about the issues of summons and my appearance before them. Now, ECI was registered in 2019. Now, these are the summonses within my knowledge and received by me. What you may see, the first summons I shot for the time. I on page 7 of my bail application.
Yes.
Para 5.13. Can you see this number 2?
Yes.
Then they issued summons on 7/7 to appear on 31/7. However, on 30th, they came to my premises and made research. And on the same day issued my summons, obviously entry number 2 and 3. On 7th July, they issued a summons to appear on 31st. Now, without waiting that I should appear, they came to my premises on 30th of July. They issued a summons, they recorded my statement, and they issued a fresh summons on 30th to appear on 31. That also I complied and appeared before them. And again on 22nd 12, 2050, they issued a summons to appear on 2nd January 24. I appeared in person before them. Then on 23rd February, they issued a summons me to appear before the forensic officer to find out my phone and to open or to analyze or to have a mirror image of my mobile phone. I appeared before the National Forensic Science University at Gandhinagar. Again, I have summons was issued on 11/3 to appear at Gandhinagar. I appeared on 19th March 2024 at Gandhinagar. Then they issued summons on 18th March to appear for 20th March. I appeared on 20th March in person. Then also may see on 1st August, they issued a summons for 2nd August. I appeared in person. On 8th August, they issued a summons for 9th August. 9th, I appeared instead of 9th on 13th of August. I did not appear on 9th. I said I'll be not able to appear. They said on telephone, they said, okay, you come on 13th. On 13th, I appeared before them. On 13th, I was arrested, and thereafter, my free statement was recorded on 14th August, 15th August, and 16th August. So the investigation which is being started in the year 2019, we are in 24, the 5 years to be completed. till they are saying that the further investigation is continuing. While opposing my first bail application, after 5 years, they said that the investigation is crucial juncture. If bail is granted, investigation will not be completed. And within couple of days, they filed as a charge sheet. If the investigation was in crucial stage, they could not have filed the charge sheet unless it is completed. So therefore, if they say investigation is completed opposing my default bail contention, then my presence now in judicial custody is not required. Because after ECR was registered in 2019, till 24, I did not do any action which would come in way of the investigation. There is no allegation in the reply that I interfered with any evidence. The person whom I alleged to have been cheated did not file complaints. It is only generated after my filing complaint against the police officials and CBI, which is annexed with this bail application. And those officers have been charged. So what I said is I collected my profit with investment. And out of that, because I got some enormous profit, because of the coin with this virtual currency which I purchased has gone from 0 to $468. Now to calculate the money, again there's a double standard. When the calculation comes with respect to mine, and they calculate the value of the Bitcoin or the coin as per today's market rate. Whereas for the double Mamanian company, they are 26,000. Why double standard for the same officers? Input is the value, it will be equal for both of the accused. For them, accused is accused. The favor has been given to those accused by not arresting them. Favor has been given to those accused by calculating value of the coin at much lesser than throwaway price. Entire investigation is a bias investigation against me because I registered as a complaint against the officials. And his entire complaint, the basic requirement of section 3 is not completed. There has to be a projection of the money obtained or derived as a result of criminal activity of the scheduled offense. Now it was my own money which I invested in the company. I gained profit and I said, you give me my profit, they had given me my profit. If I have committed any criminal act, they would have immediately launched FIR or something. On the contrary, they said, we are paying you but don't inform others, otherwise we are required to pay everyone. The money in terms of those accused in crores of rupees. But they do not find arrest. They do not want to find out those processes of crime where the general public is being cheated. Large number of innocent people, investors like me, is being cheated. I was able to recover my money. That they say you have committed a crime. So there is a definition of either crime of the scheduled offense or the definition of the process of crime is varies person to person. Now they are not on the similar action or interpretation with respect to the accused of the same ECI, same facts of circumstances. So therefore, when they oppose this bail application on the ground of the pending investigation of the process of crime, and what action they have raised as a co-accused. If the co-accused is not arrested, I am entitled to the bail on that very ground that the co-accused has not been arrested, against whom allegations are more serious than me. They have been arrested in a scheduled offence and granted bail, whereas I have been granted indemnity by the Supreme Court on the ground that my interrogation is not required. And I am not charged with failure of the argument. That was my instructions. So the facts shows absolute biasness and different interpretation by these officers on different accused. They are not straightforward, they are not fair with this accused, they are not consistent. Because they are not investigating any accused. They are investigating offense of ECIR. If they are investigating offense of ECIR, then their yardstick, parameters or ingredients will be consistent in application of arrest and filing complaint or recovery or to have the process of crime. If that is not consistent and there have been this other accused has not been arrested, then I am entitled under the law of parity. I should be granted bail. It is a similarly situated accused.
Yes.
Is not arrested and the complaint has been filed, his honorable court has taken cognizance and has granted bail. Because once they have produced, complaint court has taken cognizance, bail by warrant has been issued, they will release on bail. All those 6 accused. Then the law of parity will apply in my case because we are of the same ECIR and the co-accused. The allegations against them are more serious than me. Now, investigation is completed. These honorable court, now can you see the ground on which this honorable court was placed to reject my bail application is on page 318. Page 318. Last. I'll just read one paragraph from paragraph 13.
Yes.
Having regard to the seriousness of the offence, investigation is an initial and crucial stage, coupled with the fact with regard to the process of crime involved in this offence as revealed from the statement of various persons of the applicant, accused himself along with the provisions of section 45 of the code cannot from that there are reasonable grounds to believe. So it was only on the ground that the investigation is pending.
Yes.
Otherwise, there is no other grounds or reasons has been assigned by the honorable court who recorded submissions of both the parties, who recorded the citations which we cited at both the ends, but the bail was rejected only on the ground, according to me, my understanding, the investigation is pending.
That you have stated in para 60.
Yes. Can you continue?
Now what? Yes, yes, you continue.
Yes. So therefore, the first therefore, the first my contention on merit, because I am entitled to bail on parity, because the allegations against those accused are more serious than me. And also may see that the complaint which I filed, I have referred at page 135. sorry, 129 first. This was based on my complaint to the state government. The state government themselves pick up.
This was
I
considered.
just draw that and state the first. Other this already I have read it before and told this honorable court. Then this charge sheet has been shown in connection with this complaint at page 129 is at page 135. These are the charge sheet. Now in this charge sheet,
Yes.
the allegation page 196. It starts from 195. Just block number 5. The fourth line. મુજબનો ગુનો સીઆઈડી ક્રાઇમ ગુજરાત દ્વારા અરજદાર શૈલેષ ભટ્ટની તારીખ 23/2/18 ની અરજી સંદર્ભે હાથ ધરાયેલ પ્રાથમિક તપાસ દરમિયાન ગંભીર ગુનાહિત રીતે બંધ. It was based or pursuant to the my complaint. Then can you see page 196? They say investigation is pending for the purpose to find out the process of crime. Now where is this process of crime? Is there here on page 196. Kindly see. Second paragraph.
Yes.
They do not arrest any of these accused of this charge sheet or any other person who has been named here. Now kindly see. Charge sheet માં કોલમ નંબર 66 થી જણાવેલ આરોપીઓ પૂર્વાધિક ગુનાહિત કાવતરના પ્રથમ તબક્કામાં ભોગ બનનાર શૈલેષ ભટ્ટની પાસેના બિટકોઈન પડાવી લેવાના હેતુસર શૈલેષ ભટ્ટનું અપહરણ કરી તો for kidnapping ધવલ માવાણી I have been arrested. To get return money, I have been arrested. But these persons kidnapped me, these police officials. They have been arrested, charge sheeted. ED does not take action against them. But to अपहरण કરી આપણને મુક્ત થવા માટે ખંડણી પેટે 176 બિટકોઈન ટ્રાન્સફર કરાવવા તથા રૂપિયા 32 કરોડની ગેરકાયદેસર માંગણી કરી ને માંગણી મુજબ આ ગુનાના સહ આરોપી કિરીટ પાલડિયા પાસે ભોગ બનનાર શૈલેષ ભટ્ટ સાચવવા આપેલ બિટકોઈનમાંથી અમુક બિટકોઈન વેચાણ કરી આ ગુનાના આરોપીઓએ ભાગ પડતા નાણાં મેળવેલ છે. ચાર્જશીટના કોલમ નંબર 66 માં જણાવેલ આરોપીએ પૂર્વ આયોજિત કાવતરાના ભાગરૂપે આરોપી નંબર 11.14 કિરીટ પાલડિયા then દલીલ કોટડિયા 1600 માહિતી આપેલ કે શૈલેષ ભટ્ટ દ્વારા 1600 કિંમતના બિટકોઈન તથા 14.15 કરોડના અંજારી ધવલ માવાણી દ્વારા ધમકાવતા જે 176 બિટકોઈન ભોગ બનનાર શૈલેષ ભટ્ટે પોતાના એટલે કે આરોપી નંબર 14 કિરીટ પાલડિયાને સાચવવા આપેલ છે. કાવતરના મુખ્ય હેતુ મુજબ શૈલેષ ભટ્ટનું અપહરણ કરી ધાકધમકીથી ઉપરોક્ત તમામ રકમ પડાવી લેવાનું નક્કી થયેલ. And they collected this also. That has been referred. The various accused has been referred, their role has been referred, and what money they took is also been referred here, my lord. That is on page 203, my lord. And start from page 200. Page 200 last paragraph, my lord. 32 કરોડનો હવાલો આપેલો અને એનાથી
Yes.
yes. So these informations where it is the investigation officers, they do not take into consideration, they do not take these as the process of crime. So this is the part of the money which I received from Dhawal Mawani only. Dhawal Mawani in party has not been arrested. These officers who has collected from me the process of crime not been arrested. They say investigation is pending to find out the process of crime. So the conduct of the investigation officers is to keep me in judicial custody for indefinite period on one or the other grounds. Otherwise, these facts are within the knowledge of investigation officers.
This is
Yes.
the.
Then these entire this fact followed from the page 200 to 204 has been stated in detail. I'm not reading it again. I already read. Then is the next FIR at page 208 by the CBI.
Yes.
There also, my lord, will finalize the refer values of 4.5 crores was being taken. That is page 212, my lord, will find as reference and is conclusive on page 213, first paragraph. Conclusive on page 213, first paragraph.
That was also considered.
CBI.
CBI complaint.
Yes, that CBI officers will be, and his conduits will be invoked. So this fact is also on record. Let's assume they were not aware about this. They have blindfolded their eyes. These very facts I produce in my bail application by way of my bail application annexures with this very investigating officer has came to the knowledge. But deliberately is not looking at the averments of these charge sheets. So he cannot say that I am not aware about these facts. Because this was the part of my bail application, it was served to them. And this annexure F page 215 is the FIR based on that of the CBI. Which is being. Now, can you see 215 page, annexure F? Is this a scheduled offense against me? Now, kindly see,
Next are G.
annexure F, page 215.
Next are F is 208.
Annexure F 215.
તો 15 બરાબર next are G છે.
Any things means any record produced by him in any proceeding under this act. So therefore, this talks about the person, not about the accused. Once any person is being arrested, then he falls into the category of the accused, and then Article 20 will be triggered. Once Article 20 is being triggered for any accused, with protection of Article 20 sub-article 3 will be come in picture. So one cannot be compelled to have a self-incriminating statement. So when you are being issuing a summons, you have registered an ECR against me, citing me as an accused. So any statement recorded of me would fall in the category of the accused statement. So it will not be straightway admissible. Those statements. It could be used for the purpose of investigation. It could be seen by this honorable court at the stage of bail, but it is not straightway admissible in the Evidence Act. So the concept of admissibility came under the Customs Act. In the Customs Act, while issuing a summons under section 108 of the Customs Act for the recording the statement, the persons are not an accused unless private complaints are being filed. So same analogy is being taken here. If these enforcement officers are not the police officers, and on the day of the issue of summons, there is no FIR, therefore there is no prosecution. You are just called for the civil inquiry. Unless the private complaint is being filed, you will not be treated as an accused. That is the analogy they are invoking, and that is why they say the statement in the section 50 is admissible. But that is Supreme Court has been clarified in the recent judgment. That is not the scenario. Once, because unlike in the Customs Act, Customs is a simpliciter file number has been registered. Here they registered ECR and they say the accused. These are the accused. These are the accused of the schedule offense. So, therefore, just can you see ECAR on this issue, my lords? I'll just title of the column number 6, row number 6 of ECIR on this aspect. What is the title? Details of known / suspected accused with particulars. What is accused will be made. You see the title on page 1, row 6. Details of the accused and details of known / suspected. So known or suspected accused. Once you title me as an accused, my statement is not admissible. So you issue a summons, not as a witness. You issue a summons me as an accused. Even that I have appeared before you. As many as I stated in my application by tabular format. While appearing before you, I have given best information available to me. Now, those information does not satisfy your conscience, does not amount to non-cooperation. Therefore, I like these two judgments on this issue. Even the complaint, page 254, my lord.
Yes.
Can you see again this different double standard of those officers? Docs may see for a minute. Page 254. In this earlier complaint, though accused has not appeared, in spite of summons, not arrested. For them, they say they are cooperating. Page 254. There's a table is given. Can you see? Number 2, Dawal Mawani. 29 summons for 12/12 not appeared. 31 summons for 17/9 undelivered. 18/12 summons 6/1 not appeared. Still he is cooperating because he has attended one summons. And he appeared only once 12 February. And again he is not appeared for another 2 summons. Then same is for the Suresh Gorasia. First summons not appeared, second summons undelivered. It is unheard. The first summons is delivered, then second summons has to deliver. Then Gautam by Gorosia, once not appeared, second recorded. Vatsaben Mavani, one undelivered, second appeared. They considered all these officers, these accused are cooperating. Whereas in my case, I have appeared in all summonses. Still they say I have not appeared or not cooperating.
Yes.
So these are the double standard or the biasness on the face of it of this officer to arrest me and to linguist me in judicial custody for the reasons based known to the officers. But it is not supported either by evidence or the law to keep me inside in the judicial custody. Then the question of this, before the coming to the question of arrest, now finally see the ground P with respect to the admissibility. Page 20. In Vijayabadala in para 345. What the Supreme Court said, can you see? Be it noted that as the legal presumptions under section 24A of the 2002 Act would apply when the person is charged with the offence of money laundering and his direct or indirect involvement in any process or activity connected with the process of crime is established. It is yet to be established here. The existence of process of crime is therefore a foundational fact to be established by the prosecution, including the involvement of a person in any process or activity connected therewith. Once these foundational facts are established by the prosecution, the onus must then sit on the person facing charge of his offence of money laundering to refute the legal presumption that the process of crime are not involving money laundering by producing evidence which is within his personal knowledge. So it is not that whatever is ED alleges is the gospel truth or it is to be statement to be presumed and accepted. That is not as a contention. Then Lordship may see the three stages or the ingredients of section 3. Lordship may see grounds AA, double B and double C.
Yes.
Ground AA on page 24.
If you had argued last time also.
I just, this is to be considered because in here the allegations made in the complaint does not satisfy these grounds. Because neither is what I stated in AA, double B, double C is not satisfying. Because there are the three stages. There is a stage of placement, layering, and integration. Where is the integration? Where is the layering? At the most, based on this allegation, is a placement. But layering or integration, there is nothing about in the complaint. They only said, I am not answering, I am not answering, I am not cooperating. That's all. And for that, I have been arrested. Now, did they got the same material for those other accused for which complaint has been filed and they are not been arrested? Answer is no. In that act, in schedule offence 06 also, crores of rupees has been cheated of the public at large. I was one of them. I could recover my money and make this complaints against the police officers and therefore I am being made scapegoat, been arrested. Maybe otherwise, where are these three stages satisfaction? Unless all the three stages are complete, offence will not be made up. If there is only, let's assume I have committed a crime, earn money. That does not mean I have committed an offence of PMLA. There has to be all the three stages to be completion. This is like if I give a simple example, this is like 138 proceedings. mere issuance of the check without balance is not an offense. Issuance of check is not an offense. After statutory notice, even if I make a payment, not an offense. But after receipt of this notice, 15 days I do not make payment, then only offense makes. So it depends on the events. The PML also depends on certain events. So first there should be a schedule offense, there should be a crime, there should be as a result of criminal activity of the scheduled offense, generation of the property, and that should be claimed as untainted. Where is the claim as treated untainted? And where is the crime money? The first of all, it is even their own case. I invested on promise to get profit every day, or is the interest every day, or is the benefit 0.2% to 2%. So if I have been promised, I certainly ask for it.
I have recorded all those your submissions, so now.
Yes. Then therefore if these are the three layers
layers
are
are not
not satisfying, then the offense under section 3, punishable under section 4 is not made out. So even if it is just assumed for sake of argument that it has been made out as claimed by the AD, and there is no evidence produced along with their complaint.
Yes.
Even otherwise, the offense is punishable 7 years. Now we have seen before this also, even if the ECIR complaint has been filed in 2014, still investigations are pending. So their investigation are infancy or indefinite. It's never going to over. In none of the matter, at least to my knowledge or where I am appearing before this honorable court in PMLA, they are not made statement of any of the matters that the investigation is completed. In all matters, they are saying investigation, even after 10 years, they are saying investigation is pending. Even after 10 years, they say investigation is pending. So their investigation is not going to over in the next 10 years.
The trial is not to be completed.
It's not going to be even completed because unless the investigation is over, charge cannot be framed. Because once the charge is being framed, then defense of the accused should be open. Now, once defense is open, somebody has been cross-examined, then they come with by supplementary evidence to fill up the lacuna, which cannot be permitted in the eye of law or by the law. So once trial starts, there cannot be further because it is that is a aim and object for the prosecution as per later the section 167. If that is not achieved or investigation is not completed, then there is a fundamental right of just and fair play of the accused or to defend himself would be violated. So in such circumstances, if the trial is not going over in next 10 years, they are not going to file or declare on oath before this honorable court that is the investigation is over. So none of the ingredients of section 3 is satisfied. Then on the questions of arrest, for that I am relying on the ground O, double M, double O and double S.
The page number.
Yes. Ground O is on page 70. Section 19 has been interpreted by the Supreme Court in Vijay Mandal. Page 17, ground O. The relevant portions are already highlighted of the judgment. And the relevant paragraph of the Supreme Court I have quoted. So there Supreme Court made very clear the standard for arrest in PMLA is much higher than the standard for arrest in IPC offences. So that is what Law say page 20. Supreme Court made very clearly. Because the standard for granting a bail, stringent is the requirement of arrest. That see, are equally stringent and as a higher standard, those safeguards are ensured that the authorized officer do not act arbitrarily. So here the facts demonstrate that the entirely arbitrary action has been taken. The accused who has a more serious allegations and role has not been arrested. There they not appeared, still they say they are cooperating with according to them. I have appeared in all the summonses, still they say I am not cooperating. Then ground double M is on page 41. The judgment in the matter of Siddharth, State of Uttar Pradesh, where I have put in the relevant paragraph. Double O is on page 45. And double L is on page 47. So Supreme Court in all these paragraphs say in different judgments in different paragraphs that merely an FIR or prosecution or does not mean it to be arrested. My lord is well known the 1994 judgment of Jahangir.
Yes.
It has been followed time and again till today. Then the question about section 45. There the ground double D and double L. Ground double D on page 26. Where is the Bombay High Court? While granting bail as relied upon was the judgment of Makoka in the matter of Ranjit Singh Sharma, where the identical twin conditions were there, and which has been accepted again by the Supreme Court in the matter of PMLA in Vijayamadan in paragraph 400.
Yes.
400 and 401, which is I have reproduced on page 30 and 31. Can we see and just read one paragraph? Paragraph 401 on page 30. Bottom. We are in agreement with the observations made by the court in Ranjit Singh Sharma. The court, while dealing with this application for grant of bail, need not get deep into the merit of the case, and only a view of the court based on available material on record is required. The court will not wait as evidence to find as the guilt of the accused, which is of the court, the work of the trial court. The court is only required to place its view based on probability on the basis of reasonable material collected during the investigation, and the said view will not be taken into consideration by the trial court in recording its finding of the guilt or acquittal during the trial, which is based on the evidence adduced during the trial. As explained by this court, Nimaga Prasad, the words used in section 45 of the Act are reasonable grounds for believing, which means the court has to see only if there is a genuine case against the accused and the prosecution is not required to prove the charge beyond reasonable doubt. So if I take the section for twin conditions as stringent, the court has to hill at this stage that this accused is not guilty. then prosecution cannot get a conviction. If the court rejects the bail application holding that is guilty, then accused cannot get acquittal. So it is not that higher standard court has to, because the court is not required to evaluate the evidence at this stage. This will be decided after the cross examination of all the witnesses that will be produced before the court. So just prima facie view is to be taken for granting or not granting a bail. But it is not, preconditions are not to be interpreted as high as either acquittal or conviction. Now I am relying on the judgments. These are all the judgments of the bail in PMLA in recent days. Mostly of it 2024. Where written paragraph I have quoted my lord in the index itself. These are over and above what I have quoted in my bail application. I mean, all these judgments bail has been granted. And in none of the judgments the court said he is not guilty. Because the Supreme Court said this in all the judgments, it is not required to say he is not guilty. In all 9 judgments. Though I have quoted some paragraph, lots of men can see this others also. So this is what my suggestions about the paragraphs. And section 45 has been interpreted.
Yes.
Now, finally, these are the judgments from serial number 3 on our High Court. By upon which is prior to the amendment and subsequent to amendment, both are included. And this is the list of judgments where these honorable court, this is only with permission of tendering my lord. This is bail application granted by these honorable courts. List up. WhatsApp कर देंगे। All these judgments, either these honorable court being a sessions court, our High Court or the Supreme Court. Section 45 is not been interpreted as the court has to require to declare as not guilty or the guilty. Even in the recent judgment, the Supreme Court has granted bail on the ground of delay of the trial or the investigation. So that is the section 45 is not be treated as the bar against granting bail.
Yes.
Considering all the judgments and ratio laid down in that, if required, I can read and point out from each judgment. Or it is called upon.
Done.
Otherwise, I request the honorable court to look at into and consider while deciding my bail application. Now, while hearing this my bail application, before that one statement was been shown to the honorable court on the line, and which has been, my statement has been distorted by the investigating officer and places in other way around. It was been the statement was to the effect, it was been presented before the honorable court to the effect that one minute it is from one of my statement has been quoted. I'll just kindly see page 52 of my bail application, where I've tried to explain it. Paragraph 18, page 52.
Yes.
The applicant submitted the investigation officer made an incorrect statement that the applicant paid rupees 1 crore to Mr. Ashok Gajera of Rajkot for seeking favor for interim bail before the Honorable Court of Gujarat, which would prima facie suggest that the process of crime received are being used for further illegal purpose. Now, this was being statement was made, or it was being showed by a document to the Honorable Court. Now, in fact, what was this explanation to this? The applicant submits as exercising applicant's right to the constitutional remedy and or to the statutory remedy, either to get bail or default bail, cannot be termed in any manner as alleged by the complainant illegal purposes. The applicant submitted the statement of the applicant has been distorted by the complainant. The applicant never stated that rupees 1 crore was paid to Mr. Ashok Gajera for an illegal favor. If this statement is used, it reveals that the money was paid to Mr. Ashok Gajera to avail legal remedy of interim bail or the bail from his honorable court. It cannot be understood otherwise than what is stated in the black and white. To get a bail, to pay fees to the, see, 1 crore rupees is given that you take this money and get my bail. So now that does not mean that you go and bribe X or Y. It could mean that you go and hire a best lawyers. And the fees of the best lawyer of India, either the High Court or the Supreme Court, is well known. What they charge for appearance. It's publicly this, any this, senior counsels are charging this from 10 lakhs, 12 lakhs, 15 lakhs per appearance in the Supreme Court. So 1 crore rupees in amount of those fees is not even sufficient. In the Supreme Court, there is a known counsels. I am making a submission, my lord, is not about that I am making a submission.
But that is not concerned.
That's one of the, no, this is considering the bail, my rejecting my bail application. If required, I can show from the judgment itself. Can you see this?
I have noted. Yes, I have noted that.
Yes. So therefore, I am explaining here at this stage. It should not wait with honorable court in what the manner in which it was projected before this honorable. It was never, even the statement does not say so that for illegal purpose. It is the interpretation of the officer that it is been for illegal money. They are trying to show that this money was given towards a bribe. The inspiration anybody reads the judgment of this honorable court was rejecting the government on the contention. It gives an impression that money I tried to have illegal favor. Now, hiring a best lawyer or to approach the Supreme Court or the councils or the lawyer here cannot be termed as illegal favor. One may have a battery of 10 lawyers, one may have 100 lawyers. That does not mean there's an illegal favor. If I have money, I can spend for myself.
Certainly.
And if my money is being found to be poor, then you can say, based on the credible evidence and the material, not mere allegation, to take the view different or to, I would say, and this forgot the word, to take this view contrary to or against the accused on the ground. They just want to pollute the mind of the honorable court that this man should not be given bail. He is such kind of person that is even trying to, is following or is doing illegal means to get bail. That is what is being done. That is why this I specifically pleaded in this application Even the statement I have read, statement does not say so. And on this base, there is no statement of Mr. Ashok Gajera in the complaint. And this a person comes in and states before his authority. Because at least in the complaint it is not been made available to us. So there is no statement of Ashok Gajera to substitute this allegation made by the investigation officer that this money was given for illegal purpose. So again, this is a statement or the presentation made to this honorable court by way of the secret documents is not supported by the complaint and the statement of that same person. So the considering the fact that this offence is punishable with 7 years, there is no chance of in near future to even start with or conclude the trials because the trials of last 10 years are pending before this honorable court.
Yes.
The co-accused have not even been arrested, against which serious charges are being leveled, have been granted anticipated in the schedule offence. On the same facts, what have been alleged to kidnap and extort money for which have been granted anticipated by the apex court. Should not weigh with that application of mine to the Supreme Court that I am entitled to anticipable, then I am certainly entitled to the regular basis. After filing a complaint,
Yes.
therefore, bail should be granted on the terms and conditions that may deem fit and proper to this honorable court. And then we abide by the conditions of the terms of the bail. Please, some of the questions here.
Yes.
Please.
You have to continue or you have to ask for the time?
Actually, I was too, because there was some personal difficulty in the second session. And I leave it to the honorable court.
No, it is up to you.
I may try to complete, my lord. I will be, if subject to the convenience of the honorable court, my
I
lord,
don't hear.
because we have taken the entire day.
Yes.
I leave it to the
No,
honorable.
it is up to you because you have to ask for time.
Yes, my lord, because there was some difficulty in that, but since I am here, my lord, I will try to. Please.
Don't try then. You will have to complete it.
Yes. Because see, my learned friend has, my lord, already pointed out on facts. And I will try to show to the honorable court that what are the new or change in circumstances from the record.
Yes.
I may try to bifurcate the submission of my learned friend in two parts. My learned friend has submitted the grounds on which the default bail should be granted, and the other part is on merits. So far as default bail is concerned, in that context, my respectful submission is that my learned friend is relying on few judgments which he has already pointed out in the memo, as well as the compilation is given.
First, can you assist on the factual aspect of default bail? Then we will go on that low
Yes.
point.
Only I would not make submission only on one judgment, my lord, which is the latest 2024
But
judgment.
default bail is on based on some kind of facts. Default bail is to be asked that on this within stipulated time, the charge sheet is not been filed.
That is their contention. I will deal with that, my lord. Before that, since they are relying on few judgments, that it is incomplete for him, that is his submission. And he has relied upon certain judgments. All the judgments are of 21 and 22. But I may just pass on, which I have already given, I think.
Kapil Wadhwan.
I may say,
Kapil Wadhwan.
Kapil Wadhwan.
Yes.
Yes. I may just read few paras from that. Just to give the brief, background under which this order was passed. Para 2 says, the appellant CBI has sought to challenge the impugned order dated 30/5/23 passed by the High Court of Delhi. So and so, holding the order dated so and so passed by the Special Judge, New Delhi, by which respondent number 1 and 2 have been granted default bail under section 167(2) CRPC. So the default bail which was granted by the special court was challenged before the High Court. High Court order was challenged before the Supreme Court, wherein this present judgment is passed. Now, the Honorable Supreme Court, after analyzing the law on this particular point, Courtship may have para 22 and 23 that would be relevant. Because this will make distinction. What if the investigation is pending qua him, and what if the investigation is pending qua other accused persons? I will just read 2-3 paras. Para 22 says, in view of the above settled legal position, there remains no shadow of doubt that the statutory requirement of the report under section 173(2) would be complied with if various details prescribed therein are included in the report. The report under 173 is an intimation to the court that upon investigation into the cognizable offence, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offence, and necessary information is being sent to the court. The report is complete if it is accompanied with all documents and statements of witnesses as required by section 175 subsection 5. As settled in the aforesaid case, it is not necessary that all the details of the offence must be stated. Now, para 23 is relevant. The benefit of proviso appended to section 2, subsection 2 of section 167 of the code would be available to the offender only when a charge sheet is not filed and the investigation is kept pending against him. Once, however, charge sheet is filed, the said right ceases. It may be noted that the right of the investigating officer to pray for further investigation in terms of subsection 8 of 173 is not taken away only because a charge sheet is filed under subsection 2 thereof against the accused. Though ordinarily all documents relied upon by the prosecution should accompany the charge sheet, nonetheless, for some reasons, if all the documents are not filed along with the charge sheet, that reason by itself would not invalidate or vitiate the charge sheet. It is also well settled that the court takes cognizance of the offence and not the offender. Once from the material produced along with the charge sheet, the court is satisfied about the commission of an offence and takes cognizance of the offence allegedly committed by the accused. It is immaterial whether the further investigation in terms of 173A is pending or not. The pendency of the further investigation qua the other accused or for production of some documents not available at the time of filing of the charge sheet would neither vitiate the charge sheet nor would it entitle the accused to claim right to get default bail on the ground that the charge sheet was an incomplete charge sheet or that the charge sheet was not filed in terms of 173. So once the charge sheet is filed, here in this case also, we have filed the charge sheet. Honorable court has taken the cognizance so far as this accused is concerned, so far as other accused persons are concerned, and therefore, even if it is so, the default bail, he would not be entitled to default bail as per this.
Your charge sheet is filed within the period of limitation.
Yes, it is within 58. It is not disputed. Now, since my learned friend has taken to various FIRs and different PCs, because there are 2 prosecution complaints which are filed before the Honorable Court.
So default bail is concerned, your arguments are complete.
I am relying on this judgment on 2 counts. Because it says, because all the judgments which my learned friend has referred out 22 and 22. This is our 24. This says, the latest which says that even if it is incomplete, once the charge sheet is filed, the accused is not entitled to default. So it is undisputed that the charge sheet is filed and cognizance is taken. Therefore, I am limiting to that only, so far as his argument on default bail is concerned. Now I will take on factual aspect that the investigation qua the proceeds of crime, my lord. Ultimately in PMLA, what is important is investigation qua particular accused is not important. We are concerned with the proceeds of crime. If the money trail takes me to some accused, we will have to follow that. That is what the essence of this law is. Now, my lord, since there are various FIRs which are overlapping, my lord, and two PCs which are filed under the PMLA, I may take the honorable court to the core, my lord, this facts from which all these cases have emerged, my lord. I may invite the honorable court's attention to page 3 of our reply.
Yes.
There, if the honorable court will see, my lord, in tabular form, we have given the details in graphs of all the 4 FIRs from which this entire case, there are overlapping facts, my lord. If the honorable court will see at serial number 1, the FIR number is 6 of it.
Yes.
So this FIR, which was registered on 21st July 2018, it was pertaining to BitConnect company and its promoters, developers. So it was in general. There the allegation was that the developer, promoter and owner of this company, BitConnect, they collected huge amount of money from public and promising to invest this money in Bitcoin, and in return the investors were promised some good returns. That was the allegation in this FIR particularly. So it was in general against the BitConnect company and its promoters and developers. Now, so far as the FIR at serial number 2 is concerned, which is 3 of 18, sir, there it is pertaining to this very accused, sir. I may read the crux of this. The accused in this FIR committed offences of kidnapping of Piyush Savania, Rebuttal Mamani, who were working with Bitcoin Connect at the relevant time and extorting so and so Bitcoins, Litecoins, and some amount in cash. The applicant herein was the main accused in the said offences of kidnapping and extortion. Now, this first FIR and second FIR are as such, two different incidents. The first was in general, wherein large public was cheated, they were defrauded, and amounts were collected. So far as this second FIR is concerned, it is mainly against this particular accused who had kidnapped 2 persons of that company. This, so far as this Piyush Savania and Dhaval are concerned, they were connected with that company. Now, the reason they are saying is that I had invested this amount and I wanted to recover this from this person, and therefore this happened. But as on date, even after investigation, there is nothing on record to show or establish that he had invested this amount. Nothing is reflected in his income tax return to show that he had invested this huge amount in this company. It is not reflected anywhere. Not they could prove it from any other source that this was the amount available and we had invested. So the theory of investment and return and profit falls flat in my perspective. It is not good by them. Now, sir, they are harping more on the 2 FIRs which are at serial number 3 and 4, which the Honorable Court would find, which is filed by the applicant against some police officer and officer of the CBI. Now, so far as these 2 FIRs are concerned, it is again 2 independent separate actions which are being investigated by the competent agency. Their charge sheet is filed and trial will proceed. But so far as this our case is concerned, PMLA case is concerned, we are focusing on the proceeds of crime. There, the allegation is that this police officer or CBI officer had taken this person into illegal custody and money was extorted. That is the allegation. That is on altogether a different incident, sir. We are not investigating that. But if some proceeds of crime trail is going there, not certainly it will we will enlarge our scope. But as on date, sir, we are not there. So far as kidnapping and extortion of that accused is concerned. So the submission that we are not doing anything so far as that CBI officer is concerned, sir, we are not concerned with that. There is altogether a different FIR that some agency is already doing the needful, and we are not there. Now, sir,
His
coming back-
argument is one of the contention is that you have chosen the only applicant to get
Sir, it is
arrested.
incorrect. Incorrect
Because for other accused, you file a complaint, no arrest.
that is
For as per your case, the proceed of crime which came to the applicant that were extorted by the accused of the third FIR where he is complainant.
sir, what is happening?
Fourth case is of CBI. The case is that some 5
Sir,
crore were
I agree.
demanded. And this amount is been paid, which as per your say is proceed of crime.
I will make that.
And
clear.
therefore, his submission is that there is completely bias and
I'm obliged.
prejudice investigation by your officer by not arresting all those person or investigating in that regard, where that money, as per your say, he gave it to the other, which was the proceed of crime received by him. And your duty is to get all the proceed of crime. So you have chosen only one person to get arrested.
Sir, it is incorrect. I will point out lordships. I may have take this on the report to the very next page. I had taken to page 3. Now page 4, sir, of that reply.
Yes.
Sir, is it tabular form to that in a machine or just paragraph immediately thereafter on perusal of am I reading it on perusal of the facts of the above said all the FIRs, it is evident that the offences committed in the said FIRs are completely independent. The process of commission of the scheduled offences and termination, possession, and acquisition of the proceeds of crime by the accused persons in FIR number 3, that is this applicant's FIR, dated so and so, was separated prior to the offences involved in 2 and 8. Sir, what has happened is the date of FIR is different and the date of offense is different.
You are right. Your concern is with regard to POC.
Correct.
Now, as per your say, he got some money by kidnapping those 2 persons at Surat. Now you have, this accused has used this money to give it to the CBI officer. Part of this money, which is as per your say is POC, that has gone to some police person.
So far as POC is concerned, sir, we have already taken the action. Because certain.
So there
sir,
is
what is
that his contention is that for best reason known to you, you have chosen only this person.
sir,
For other, where proceed of crime has gone, you are not doing anything because those people are police persons.
I appreciate.
And it is his specific case, okay, because he filed a complaint against those police persons, including IPS officer and CBI officer. Now, all of them have targeted this person.
Sir, it is incorrect because
And you are in he-
my learned friend has read the ECIR. If the honorable court has seen that ECIR, it emerges or the source of this ECIR is to these FIRs at serial number 1 and 2.
Hmm.
That is the reason. Now, if proceeds of crime, because the arraigning of an accused is one thing. If the certain set of accused are there in the schedule of offense, the same may not be there in PMLA case. Because we are concerned with the
but
proceeds of
that is,
crime.
he is very specific contention,
Yes,
that POC. He is not asking
But
whether.
sir, here, Lordship will appreciate that it is not like a routine case. For example, if some property is derived, which we can see, here
Yes.
everything is virtual.
He has stated, if POC is concerned, this fact was well within the knowledge of your officer. And at least, even if believe for the sake of argument, he was not aware. But when he filed his first bail application, then at least that POC is not noticed by your officer. And therefore he is biased for reasons best known to you.
But Lordship may have a look at the statement that will answer the question.
After filing charge sheet, one cannot show anything which is not part of the charge.
It is.
He must
Your
supply,
statement. It's
he
your
must
statement
supply the copy of whatever is citing.
Sir, it
He
is
should
the
give the page number of the charge sheet.
statement which is part of this. I am not
Then
showing
he
you.
must say the page number, so I can refer, I have a charge sheet with me. He cannot supply anything to the board and which is not given.
No,
to
I am
us.
only giving the statement which is.
Whatever
given by
they
the
give,
I
but now charge sheet is filed, I will take objection.
That is the question. He is
It is a part of it.
And just give the page number, I am telling you.
कौन आ तारीख में statement मैंने कही दो ना એટલે પતી જાય મારું
સર એટલું બોલ્યા હોત કે કયું પેજ છે તમે તરત કહી દે
હા તો કહી દો ને એમને
આ કહી દીધું સર 597
યસ
એટલે સર જે કિડનેપ કરીને છે that is what his version is 32 કરોડ નું જે કહે છે because sir it is entire trail which is we are tracing. And one after the other witnesses, as they say that this money has gone to this person, we are following the trail.
so that is his contention was that you are
He can make any allegation that we are biased and everything, but.
then you
the fact
justify
remains-
that
But the fact remains, sir, that our ECIR pertains to these two FIRs. We are focusing at present. The PO signal. Page 18. This is not what is revealed during our investigation. This grievance is that we are not investigating so far as other
page
page 18 of our reply, sir. Since it is Roman, I have got some
page 18 paragraph
the last paragraph, 4.18 no last paragraph. Something which is in bold.
yes
The process or activity connected with proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. Investigation has revealed that Shailesh Bhatt as a result of schedule offence as per 3 dated so and so and charge sheet filed in the said FIR statements of various persons had derived the following properties which is proceeds of crime. The first one is on 1/2/18, 2091 bitcoins in Bitcoin wallet address bearing number so and so. Now, Lordship may have a look at this wallet. It is a typical wallet which is virtual. It is not that in a routine case there is some property which we simply any officer can go and attach, or that is the difficult part, sir, of this case. Then the second one is on so and so date 11,000 Litecoins equivalent to 166 bitcoins in the Litecoin wallet address so and so, and then 14.5 crores cash in an account with so and so Angadia. So these are the three main proceeds of crime which we could identify so far as this applicant is concerned. Now, during the course of investigation under the PMLA, it is revealed that apart from the said 2091 bitcoins, Shailesh Babulal Bhatt has also received another 200 bitcoins, which were also credited in the Bitcoin wallet address bearing number so and so on 3 to 18. As per the statement of Dhaval Mamani in the section 50 of the PMLA, the said 200 bitcoins were also extorted by Shailesh Bhatt from the web wallet of Bitcoin. Accordingly, as per the investigation conducted under the PMLA, Shailesh Babulal Bhatt had derived and obtained a total 2291 Bitcoin, 11,000 Litecoins, and ENR so and so. Thus, the said properties in the form of cryptocurrencies and cash are the proceeds of crime in terms of so and so. It is also revealed from the investigation under PMLA that after deriving the proceeds of crime in the form of 2292 Bitcoin, so and so, Litecoins, and cash, further derived the proceeds of crime in the following manner. So, after deriving this, there is a diversion of the fund where we could trace this. Now, the first one is, as a part of proceeds of crime in the form of 503 Bitcoin was transferred by Shailesh Babulal Bhatt to Jignesh Morodia, an accomplice of Shailesh Bhatt in the crime in FIR number so and so. Has recovered an amount of the tune of 16.5 crore and 2.5 kg of gold from Jignesh Morodia, which were the same proceeds of the same 503 Bitcoin received by Jignesh Morodia. Out of the 503 Bitcoins, 20 Bitcoins were transferred by Jignesh Morodia to Manoj Kyara in the said CR number so and so. Out of the 20 Bitcoins, 5.99 so and so Bitcoins and INR 20 lakhs, sale proceeds of Bitcoins were seized by the CID crime from Manoj Kyara. Thus, Shailesh Babulal Bhatt was actually involved in the process of transferring and thereby concerning the proceeds of crime. B. Part of the proceeds of crime in the form of 260 Bitcoins was transferred by Shailesh Babulal Bhatt to Nikunj Bhatt. Out of the 260 Bitcoins were seized by CID crime to Nikunj Bhatt. Thus, Shailesh Babulal Bhatt was actually involved in the process of transferring. So, these are the concealment and diversion of the funds which he had received as per our investigation.
Please, I accept.
Yes.
Then C. Shailesh Babulal Bhatt under section 50 of PMLA claimed that out of the proceeds of crime in the form of Bitcoins, he had given 851 Bitcoins to his sister-in-law named Nisha Gundalia for keeping in her safe custody. However, Nisha Gundalia in her statement stated so and so that she had not received any Bitcoins or cryptocurrency from Shailesh Babulal. Thus, Shailesh was actually involved 851 Bitcoins. Out of the proceeds of the crime in the form of cryptocurrency, Shailesh Babulal transferred 4.5 lakhs USD to one Sanjay Kotadia for trading in cryptocurrency at the trading platform of Binance Crypto Exchange. Thus, Shailesh Babulal was actually involved in the process of transferring and using the same part of the procedure. So, likewise, sir, we have been tracing, but the difficulty is that since it is a virtual currency, we are facing some difficulty. Now, my learned friend has said, page 109. Page 105 first. Page 105 of the compilation of my learning. In the middle portion, where in more detail, accordingly as per the charge sheets filed in the said FIR number 18, stated so and so, Shailesh Babulal Bhatt by allegedly committing the schedule offences derived so and so. Now, sir, here he is making an allegation that there was a mistake. Sir, we have not said that charge sheet is filed against him or against anybody. We are saying that in this particular FIR, charge sheet is filed where this is revealed. If the honorable court is kind enough to see the words, accordingly as per the charge sheets filed in the said FIR. So, pursuant to the registration of that FIR and filing of the charge sheet, we are making this statement. It is not that against some accused the charge. We are not saying that, my lord. He is saying that their charge sheet is not filed. So, it is not a misstatement, my lord. We have not said. charge sheet is filed in the FIR. And then again we have given the details of the POC. In the same manner, my lord, 109. So far as further investigation, that aspect is concerned. Then in the reply, we have sir very categorically stated in para 13, page 109, last line. Further investigation pending in the case. Further investigation in respect of the remaining proceeds of the crime is in progress. Which is a fact, my lord. As revealed from the various statements that the money has travelled to different hands. And therefore, further investigation with respect to proceeds of crime is in progress. And the complainant reserves its right to file supplementary complaint if required at a later stage. That is the liberty that we have not sought. But I feel that my learned friend is writing on two different roads. On one hand, he is saying that I may be granted default bail because it is not filed. But we have filed the charge sheet. There, the cognizance is taken by the honorable court, and therefore, as per that judgment, my lord, in manifest submission, once the charge sheet is filed, my lord, and cognizance is taken, the question of default bail would not arise.
Yes.
And so far as other aspects which are concerned, my lord, my learned friend has raised, it was also previously raised in the first bail application, which my lords have dealt with. I may just point out that from the order, page 308.
Why also refer the order, earlier order?
My lords have dealt with this aspect of the para 2.3 of that.
Yes.
There also the allegation was that there was a non-cooperation and everything. It has been dealt. So far as arrest, non-cooperation, grounds of arrest, everything has been argued and it is already dealt with by the honorable court in the first bail application. So I am not repeating it. That is what. It may not happen that I am not answering to the submissions. That is the only reason. My learned friend has stated again that that amount of 1 crore which was given to one Mr. Ashok Gajera. Lordship may have a look at the second last page of our reply. Here the statement which was recorded by the agency has been reproduced. Serial number 3, Ashok Gajera, that part. When I was on the run in the said case of extortion and kidnapping, but this is the statement of the applicant wherein he has given this version and it is reproduced as it is verbatim. And at that relevant time, he was absconding. Even non-bailable warrants have been issued by other courts at Surat. When I was on the run in the said case of extortion and kidnapping, I gave rupees 1 crore to so and so, who is a builder in Rajkot. Now, these words may be marked to seek favor. It is not that to avail some legal remedy that he is spending this amount.
Not illegal.
I am not. I am only saying that what has been stated by him is reproduced. It is what the statement is, and I am reproducing it as it is now. As per the verbatim version.
I continue only that earlier bail prior to the charge sheet, it was protected as illegal purpose. That is what I am objecting. I am not saying I have made a statement.
I don't want to make an issue on this, but this is what he has stated, and I leave it to the discretion of the honorable court to interpret in the manner at deemed fit. But this is what he has stated before the agency, and this is what we have reproduced. That we are not making any misstatement or projecting something. On the contrary, he is making hue and cry for now. That I have not stated so, but it is what he has stated before the agency, and we are reproducing.
Yes,
I've just written some points and I'm trying to figure out. So far as investigation carried out so far in this case, two PCs, that is already forming part of. So I'm not taking the honorable court to each and every aspect of those PCs. Otherwise, at length we have mentioned the role of this particular accused in this PC. And so far as previous investigation which is there already on record, both the PCs are part of this compilation,
which one?
this bail application.
Yes.
Yes, ma'am. Yes, produce the entire PCs. So I'm not taking the honorable court to go
If
that.
you wish, you can point out.
No, I just want to point out that the first PC, then his name was not there. Which was filed in 9/23. In that PC, he was not there. In this recent PC, which was filed on 10th of October, his name he is the sole accused here. Because at the first point of time, during investigation of that complaint, his name revealed and we completed that part of proceeds of crime and then we filed this PC.
So you are only on the 318.
Please,
Your this ACIR is on the basis of 318.
yes, 318 and 618.
618 both.
So ultimately, sir, the main FIR against the bid collect company and its developers, promoters. So the entire fraud.
But there he is not an accused.
Where?
In
In
6
6 of 18, he is not.
He
In
is
3
not
of 18,
accused?
He is there. In 3 of 18, he is there.
3 of 18 he is here.
Yes. So these two FIRs are the very basis of our ECR. And on that basis, we have started. Now, sir, coming to the grounds on which he is urging the bail. I mean, minors have already dealt with so far as other aspects grounds are concerned. We have already filed a detailed reply, pairwise reply, covering almost everything that he has raised. So our detailed reply may be considered. Now, broadly, we are on the principles of bail. In my scriptural submission, this is a case wherein if he is released on bail, there is all likelihood that he would tamper with the evidence because this is a virtual currency. At present, he has no access because he knows the passwords and everything. If he is released on bail, my lord, there are all chances that this money could again be diverted, like he has done in past.
Yes.
Because this is the reason that being a virtual property which can be operated to a certain mode, if released on bail, there are chances that he would tamper with the evidence and therefore at this stage, he should not be granted bail. So far as change of circumstances is concerned, our investigation on the aspect of proceeds of crime is still going on. So, if again released, he would be influencing the investigation as well. Because ultimately, if the proceeds of crime are not traceable, if they are diverted like he has done in the past, but again, it would frustrate the very purpose for which this detailed investigation is carried out. And therefore, at least not this aspect may be kept in mind. That is my humble submission.
After my very friends, permission. What you see was a document which my mother cited. Talking about.
Yes.
Apparently seeing that. The first aspect is that paragraph 3 last line. Paragraph 3 last line. It was a public money of 34,000 crores. Remember the honorable courts?
But
Para 3 last line.
we are concerned with the principle in this document.
Yeah, I'm showing both.
No,
Principle,
will
I'm showing principle along with the facts. Principle along with, because these judgment deals with on the client that there's an investigation against the co-accused is pending. And so those like prosecution then come to that statement. Documentation para 10. Okay. The submissions of the prosecution. Merit paragraph. The learned ESG for the appellant vehemently submitted that the charge sheet was filed by the appellant CBI on the completion of investigation was 75 accused, including the present respondent, stating that now can you mark this line, stating that further investigation was some other accused was pending. In my not got it? Because that specific case was the investigation for other accused is pending. Here what my learned made a statement that investigation for the process of crime pending. Here says that what is the crime is process of crime, not the accused. That is what my learned submissions. The process of crime is the main, and I am the only accused being shown here. And it is the case is that I only take entire process of crime with me. So, and then there's a further, this is a summation of the prosecution in that, and again, the para 13 analysis starts their analysis statement.
Yes,
Para 13. Merit.
yes.
In the instant appeal is the main question that calls for our consideration is whether the respondents were entitled to benefit of statutory right conferred under the proviso to subsection 2 of section 167 on the ground. Now can you mark this? On the ground that the investigation past some of the accused in the FIR is pending. Here is the investigation against me itself is pending because the process of crime. I am the only accused who has taken the process of entire process of crime. It is their own case. Then, in these facts, the judgment has been delivered. That is the investigation for other accused was pending, and therefore this person was not entitled to 167. Then further, the observations. Finally, see the para 19. Para 18 and 19,
Yes.
Can see para 18. The instance case as transpiring from the record, the respondents A1 and A2 were arrested in connection with the FIR in connection on 19/7/22 and report running into the 900 pages and section 172 was filed by CBI against the respondents along with 73 accused on 15 and 22. In the same report, it was stated in para 66. Now, can this mark is what is stated? With regard to the ascertaining roles of the remaining FIR name accused specifically, remaining named FIR accused, namely Sudhakar, so and then last line, and other connected issues, further investigation 173 is continuing. So the plaintiff was specifically named accused, investigation was pending. And then para 19. Am I clear, madam? I am not reading entirely to save the time. The special court thereafter had taken cognizance of the alleged offence as per the order dated 26/12/11/22. It appears that earlier special court had rejected the application of respondents seeking statutory bail under 167 to CRPC. However, that time the issue was for the offences against the respondents. So once appeal was already rejected under 167(2), then para 20. Any para 21?
Yes.
The bone of contention raised by the learned senior counsel for the respondents in this appeal is that the appellant CBI having kept the investigation open for other accused as stated in Para 66 of the charge sheet, the ingredient of section 173 CRPC could not be said to have been complied with, and therefore the report charge sheet under section 173 could not be said to have been complete. Because for other accused, not the same accused. And same was Godfrey para 23, with my letter friend said again. Can you see that para again? Is relied upon by my friend. Para 23.
He has read it.
Can you see? In this portion where it is underlined, somewhere in the from the line after the I just read this entire underlined portion. Once from the material produced, once from the material produced along with the charge sheet, the court is satisfied about the commission of an offence and take cognizance of this offence anything committed by the accused. It is immaterial whether the under the investigation in terms of 173(8) is pending or not. The pendency of further investigation. Now I will mark from here. The pendency of the according to other accused. It is very clearly the Supreme Court has distinguished the facts. The other accused or production of the some of the documents not available at the time of the charge sheet. So it is for other accused, benefit will not be given. So this is the distinguishable judgment on the facts. Because the case where the from other accused investigation pending and therefore it is being said. Here even in this reply, they do not say in my case that investigation for me is completed. There is no statement. On the contrary, it says a process of crime which they are even and that is the main purpose. That is itself is a pending. If the process of crime is pending, then investigation against me itself is pending. This is my first contention.
So now it over.
Yes. Second about my learned friend in the tabular form in their reply. Now kindly see they are going reverse, man. Page 3, my lord. That the same table, just for the purpose of date only, my lord. Can you see? Can you the reply?
Yes.
Now kindly see, if first FR was filed by me, that is on seal number 3. Can you mark the date? 8th April 2018. Then FIR number 03, that was May 2018, and then FIR of the July 8. They are going reverse. First, I log an FIR, then this FIR against me. Because I log an FIR against the umbrella police officers, including an IPS. And therefore, FIR is registered against me after 1 month. Then my learned friend said, there is nothing to show that I invested money or I had shown in my income tax accounts. For that, can you see my bail application ground double G? The observation of the Honorable Supreme Court. Unaccounted money does not make an offense. That is what the Supreme Court said. Prosecution. Ground double G. On page 35, prosecution. I will read 2 paragraphs on this issue. The Supreme Court judgment of Vijay Madalla. Vijay Madalla paragraph 250, 251, 252 and 253. The 4 paragraphs I have copied in my ground double C. Where what is the process of crime is been described. Now can you see page paragraph 251 on page 35. Very much.
Yes.
The process of crime being the core of ingredients constituting this offense of money laundering. That expression needs to be construed strictly. In that all properties covered, recovered or attached by the investigating agency in connection with the criminal activity relating to a scheduled offense under the general law cannot be regarded as process of crime. Let's assume for sake of argument I have not shown anything in my income tax record. It was my unaccounted money which I invested with them for sake of argument. Let us take for argument. And that does not make an offense. That's what will further explain here. There may be cases where the property involved in the commission of the scheduled offense attached by the investigating agency dealing with this offense cannot be wholly or partly regarded as process of crime within the meaning of section 2(1) new of the 2002 Act, so long as the whole of some portion of the property has been derived or obtained by any person as a result of criminal activity relating to this stated schedule offence to be process of crime. Therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity to a scheduled offence. To put it differently, the vehicle
Yes,
used in commission of scheduled offence may be.
Yes, I
attached
have
as a
got your
property.
argument.
No, I'm saying, my unaccounted money does not make, that is, I did not have any.
His
That
submission
that's
is,
not exactly stated here. This allow me just one paragraph more.
I can't, his submission is that during entire investigation, you have not point out the source, how you
No, they are
invested
not
such a.
taking my say. I'm saying I have even their own.
It is
case, I
their
have
say.
invested 1.70 crore, which I have read. Even that it is part of their arrest order itself, that I invested 170 crore. 170 crore.
If it is not your say that you have invested any amount,
No, I'm saying I have invested 1 crore.
see, you are saying
1.7 crore.
that he invest as per the say of ED, he has invested 1.7. It is the say of ED, not your say.
That is my skin, that there is their case
He's
also.
claiming that it was my investment and it was.
His contention is that you did not give any, how you have made that investment to show your genuineness or bona fide.
Only with the that they had given it to me. What they say, how did I got 1.7 crore? That is I have not, so that is what their case.
If it-
My pass 8.7 crore.
So far as the decision which you are pressing upon, okay, unaccounted money, there cannot be,
That's not me, it's my unaccounted money which I invested.
but then
What my friend is trying to say.
His
my
friend is
income
trying to
tax
show
goes
that-
away.
his contention is that you did not made any investment. There is no evidence to show that it was 1.7 crore you invested in
That's
that.
what I'm answering to my lord. They are trying to show
And-
from my income record, my income record, my income में बतानी नहीं. मतलब मैं कोई investment करूँ नहीं.
He responded to your contention. It was my money which I invested.
That is what I'm answering. That only my money.
I got high returns, and that is my money. It has no connection with the any sort of crimes or proceed of crime. To that he responded.
Yeah, unaccounted money does not make an offense of money laundering. Can you see this? Allow me to read this one paragraph, page 36. To put it differently, is a vehicle used in commission of scheduled offense may be attached as property in concerned case. It may still not be a process of crime within the meaning of section 2(1) of the Act. Similarly, possession of unaccounted property acquired by legal means may be actionable for tax violation and yet will not be regarded as process of crime unless the concerned tax legislation prescribes such violation as an offence and such offence is a scheduled offence.
It goes
So this is
without
very
saying.
clear.
So it does not require even. Proceed of crime means an offense has been committed and you have derived something.
Correct.
There might be many breaches.
No,
Then
sorry. His contention is that 8.7 crore જે મેં invest કર્યા એ જ નથી કર્યા અને મેં લઈ લીધા. I said I have invested it, but it is their own case. Since I did not have an account, I have unaccounted money. But merely having unaccounted money does not make an offense. That is on trying for quoting of this paragraph. Supreme Court made very clearly. If my unaccounted money, even the unaccounted
That would
money
be for
by
any other-
by let's say by agricultural activity, I have the money.
unaccounted money, you would not show in a, you don't show in a written also. But that is not an offense. No, that won't come. That's very even, it is not the aspect of the PMLA also. Otherwise any amount would be proceed of crime.
Correct. So
Suppose
therefore-
you don't give your receipt of your legal fees. If that is true, then it would be proceed of crime.
So therefore, what my amendment made a statement that there is nothing to show that the applicant invested or applicant had source of money, it is not correct, and it cannot be gone in. Even if my unaccounted money which I might have acquired by legal means is not there. Then my amendment is the two FIRs.
I think you are responding more than what he has. But he has taken some 10-15 minutes. Now you are answering more than
Not just completely.
even after arguing for the entire day. So curtail in one or sentence only, because I have heard you in a.
Those two FIRs which I filed first. in that both the FIRs, I made very clearly the money which I received from Dhawal Mamani has been gone there.
Yes, that you
It is
raised,
very clear.
you argued that.
Yes, so therefore, what they say, we are not aware about it is not correct. Can you see, this charge sheet method I have marked.
They are very much aware.
So I'm just supplying, this charge sheet is a blue flag, where in my state, first statement of 30th July itself,
You stated in your statement.
about this, both this FIR, people
they
reading
can't-
also, can you say this? I'm not reading in this passing
No.
time. Right.
It is there. not referred
It is there.
No, it is not referred. What we say, we are not aware, we have not done it, now we will take it, that is what they are saying. And it is part of my first
My
statement
learned
of
friend is
30th of
mixing
July.
all the four FIRs, that is the difficulty.
No.
All are overlapping.
It's not
And
that,
therefore, date of FIR
If
is not
I
relevant,
first
date of offense is relevant. The sequence is that way, and therefore we have clarified after the tabular form. And so far as section 24 of PMLA is there, not, there is a burden on him, it is a reverse burden.
that I have already shown judgment, I'm not, but can you see this statement, my lord? One,
But reverse burden, when?
Pardon?
Reverse burden, when?
I may read.
But
Just
when,
like-
when?
In any proceedings under this act, it is for them to show if they are saying otherwise. Otherwise, it will be presumed that it's a proceeds of crime. Let me just take the section 24.
that has been explained by the Honorable Supreme Court, I have now T, I already said.
It says not burden of proof in any proceeding relating to the proceeds of crime under this act. In the case of a person charged with the offence of money laundering under section 3, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering.
And I'm proven now, draw
Authority or
this
court.
state.
That is authority or court. Lord. He start with section 3, Lord. Now,
Authority means
authority or court
there are,
And you will the authority,
that,
and court.
not this authority.
see, you are the officer of it.
No, no, no. Yes.
Now, so far as in the context of proceed of crime it is stated, it would be presumed that it is the proceed of crime unless contrary
Correct.
is proved.
So presumption is there.
Presumption is there, but that stage when before adjudicating authority one goes and says, yes sir, this is not my proceed of crime, this is my legal money or XYZ money. Now unless it is proved by you that it is proceed of crime, that presumption cannot be invoked.
It will apply to all proceedings under this act.
No, it cannot
Yes,
be.
yes. That is,
See, then if it is before the court, unless the contrary
and
is
therefore the
proved,
word used is court.
Court.
Authority or court, that is authority.
but this presumption can be raised when the question arises whether it is proceed of crime or not. Now, as per during the course of you start investigation,
But therefore it is says that once the person is charged for the offence of money laundering under section 3.
yes, so now when he comes to the court, yes sir, this is not proceed of crime, then he will have to give some evidence. That burden is being shifted
that is
upon you.
correct.
But the very basic principle of presumption, however, whatsoever strong it may be, first, the foundational facts should be established by you.
I agree, Lord. That is what. we
Once
have
you
done.
establish,
Lord, in my-
then that burden
my
goes
lords are
upon him.
absolutely right.
Now, this burden is strict than other burdens. Now, if he goes before the adjudicating authority and says, you point to, sir, this is the property which is proceed of crime. Someone goes there and says, sir, this is not proceed of crime, this is my own property. Then that burden goes upon him to satisfy the authority.
Absolutely right.
That is the authority. Now, when it comes to the court,
Lord, had
But
it
then
been- had it been
merely
any
because-
allegations without any, Lord, now we are.
basic, you will have to prove that.
That is not.
Only then presumption would arise.
Now we have already filed a complaint.
If
Court is
see,
required-
if your submission to presume right now as a gospel truth is taken, then there is no reason for any trial also.
I'm not. What I'm trying.
You can please realize that so far as section 24 is concerned,
Lord, once
that-
a person is charged, Lord, now the case is that we have already filed a proceeding. My lords have already issued a summons.
then that basic facts you have to, just like he has
Lord, that
also,
is what we have done, Lord. That is what my response.
then you, that's,
That we have put enough material before the honorable court based on which the cognizance is taken under section 3.
see,
Therefore, this would come in play. That is what my respectful submission.
on this stage, the court is very
Lord,
good.
this will apply to all proceedings under the act. That is what it
Yes.
says. At every stage. Whenever there is a proceeds of crime, and a case of money laundering,
Then
whether
the-
before the court or authority.
See, then, so while deciding the bail application, court will have to look, that court will do it. But when you are making submission, that presumption cannot be treated as a truth.
Correct.
That court has to, otherwise what would happen? You will file a case under PMLA, say, sir, there is presumption, forget everything.
Not even for a moment in time.
Ah,
We have, my submission is that.
even
it's
section
not-
45 twin condition.
had it be at the stage of VCIR, my words are right, but now we are at the stage of PC. There is no material, cognizance is taken under section 3. And therefore this will come into picture, that's what my submission is.
On this section 24 issue, I've given a bunch of our high
Yes,
court
sir,
judgment. Just I'm just pointing out page process is not. The judgment is C number 3 is a judgment of Jignesh Bajewala at page 38 in paragraph 18 and 19. This very issue has been dealt with by our high court and court said not at this stage is not facing. Paragraph 18 of is very same example where I appeared, so that I'm with opportunity I'm saying, but it's exactly the code is noted in paragraph 18 and 19. And then that's, and that is my last submission of my law. My learned friend said last word were tampering with the evidence. This the incidents of 2018, ECL registration 2019, 5 years has gone. They have not alleged anything in 5 years. I have tampered with evidence. And I have appeared. So now if I get bail, I will tamper. There is no basis, no foundational facts for that. As per the Sanjay Chandra, mere allegation of tampering evidence is not sufficient. They have to show something more to substantiate that allegation. Para 39 onwards, put 39 to 46, my lord is aware about. In Sanjay Chandra, Supreme Court made very clear, mere allegation is not sufficient. And in this blue flag, my lord, I have made facts available about these two applies which I find, my lord. They were very fast. Blue flag. And orange is my statement starting. In those.
Now it's enough. Now, thank you.
So thus, I have this blue flags, blue is this, where does I pass on information about the money extorted by the police officers and CBI officers. It was a very bad first statement of 30th July, it's been made to inform them. Learned princess, we are not aware, now we will take action, it's not. It is the selective approach, I would say. Please, come on.
So this was, I had gone through this last time also.
Doctor, have this, I will collect it later on.
We- Monday, 28.
It would even be in condition 45, it would be there even today.
Monday. Okay.
Okay, sorry.